10 o'clock. Can we call this meeting to order? So let me start with taking attendance here. I know Commissioner Hill Wilson is absent today, had a trial commitment. Commissioner Parcells.
Present.
Commissioner Rutherford. Here. Commissioner Caruso.
Here.
Commissioner McKee-Vassallo.
Here.
And Commissioner Leipold.
Here.
Let me start the morning by introducing everybody formally to our two new commissioners. I'll start with the most senior of our new commissioners, Commissioner McKee-Vassallo, who had been appointed by the governor to the vacancy that was left from our former chair, Shelley Sims. She was appointed on November 1st, 2023. A little bit of background, I've known Commissioner McKee-Vassallo for a number of years in the Philadelphia legal community. She is a graduate of Temple Law School. She clerked for Judge Williams on the Court of Appeals for the Seventh Circuit and Judge Stengel, formerly common pleas judge in Lancaster County and the chief federal judge for the Eastern District of Pennsylvania, and has a wonderful background for the commission. So welcome to the commission, Commissioner McKee-Vassallo. Our most recent appointment, which pleases all of us to have a full complement of commissioners, is Tom Leipold, who was appointed by Senator Ward, the President Pro Tem of the Senate, on January 2nd, 2024. So if I get that right, that was about 8 days ago that
8 days a week.
Commissioner Leipold has been a commissioner. He replaces our longtime Vice Chair, Mark Corrigan, who both of the replacements are going to be hard to replace. Both were amazing commissioners for whom the two of you are taking their seats. Commissioner Leipold has a similar wonderful background for the commission. He retired after 20 years from the Columbia County District Attorney's Office. 8 of those 20 years was not in kind of the top seat, pushing papers or making speeches, but he was the first assistant district attorney doing the real work of the office. Not that the elected district attorney did not do that work too, but he, as elected district attorney, if I understand correctly, also continued to try cases, including homicide and other types of cases. So a wonderful background to joining the Ethics Commission. So welcome to both of you. Pursuant to the requirements of the Sunshine Act, we must announce the holding of an executive session at the public meeting immediately prior to the executive session or the next meeting immediately thereafter. There was an executive teleconference held on November 13th, 2023, and an executive meeting will be held today, January 11th, immediately following this session, to review matters that by statute are confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review of confidential opinion requests, the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, and other administrative matters. First order of business is the minutes. Everybody has received a copy of the public meeting minutes from October 4th, 2023. I have a proposed amendment, just a typographical error to the meeting minutes on page 6 of 6, where we were recognizing our former chair, Shelley Sims. I think the word rewards was supposed to be awards. So I'd move to accept the meeting minutes with the modification. Is there any other questions or modifications to be offered?
I'll second your motion.
Thank you. The motion second. Any discussion? Hearing no discussion, all in favor of approving those meeting minutes, say aye.
Aye.
Aye. Any opposed? The meeting minutes will be accepted.
I will
Mr. Chair,
abstain.
I think we need to do abstentions.
Can I abstain as well?
Yes, so let's mark the abstentions of Commissioner McKee Vassallo and Commissioner Leipold. Okay, let's move to, there are several civil penalty orders. There is 2 consents. Let's take them separately. Does that make sense?
Sure.
Commissioner Reddycliffe, do you want to start with the Porter case?
Sure. The Porter, Nathaniel Porter failed to timely file a statement of financial interest for a calendar year 2021. The respondent has submitted a consent agreement proposing that the commission find that the respondent failed to timely file a statement of financial interest for the year stated and impose the civil penalties that I will detail. I am of the opinion that this consent agreement is a proper disposition of this case, and further that the commission should impose the civil penalty agreed to by the parties by the party per the consent agreement. Mr. Chairman, I move that this commission approve the consent agreement submitted for $150 civil penalty for failure to timely file a statement of financial interest for calendar year 2021 to respondent Nathaniel Porter. And further move that to the extent that the respondent has not already done so, he shall be ordered to pay the recommended civil penalty amount agreed to by the parties per the consent agreement within 30 days of the issuance of the commission orders. And I further move that to the extent that he has not already done so, he be ordered to file a complete and accurate statement of financial interest for calendar year 2021 within 30 days of the issuance of the commission's order.
Is there a second?
Second.
Motion's been seconded. Any questions? Any discussion? Seeing none, all in favor of the motion to adopt the consent agreement, say aye.
Aye.
Aye. Any opposed? Motion carries.
The second,
Why don't we pause, if I could ask you to
Sure,
pause for a second? I know we wanted to, the second matter is the matter of Emesi Bartha. I may have mispronounced Ms. Bartha's name. I understand, Ms. Guilfoy, that we had Ms. Bartha available if there's questions.
Yes, I'm gonna reach her on her phone right now.
And is someone from the investigative division on Ms. Bartha's case available to respond to any questions?
Yes.
Good morning, Ms. Bartha.
Yes, this is she.
Good morning. This is Bridget Guilfoyle from the Ethics Commission calling.
Yes,
And
yes, ma'am.
the commission is getting ready to discuss your matter, so we wanted to get you on the line so you can hear the conversation and answer any questions that they may have. I have you on a Bluetooth speaker, so if you can't hear the commissioner speaking, please let us know and we will move the speaker around for you. And if you don't hear the questions that are asked of you, again, please let us know and we'll make sure to remedy the speaker situation. So
Okay.
with that, I turn the matter over to the commissioner who is going to present the facts of the case, okay?
Okay, thank you.
Sure.
And you may proceed.
Ms. Bartha, can you hear me?
Yes, I can.
Thank you for joining us today.
You're more than welcome.
So,
Thank you.
it's my understanding that you failed to file a statement of financial interest for calendar year 2021.
To be honest with you, sir, the most honest answer is that I was new to the system. I didn't know what I was doing, and whatever happened, you know, it was new to me, and then I didn't seek no counsel or advice from anyone. I just did whatever I thought I needed to do, or, I never worked for the state, so,
Okay.
yeah.
When
that's the honest
when
answer.
did you begin working in the district office?
Yes, sir.
When? What you,
In 2020.
2020.
April 14.
So this would have been your-
2020.
okay, so this would have been your first,
Yes,
finance.
sir.
Do you work with anybody else in that office?
Just one person.
Okay. So one of my concerns was the notification that district employees receive. And did you go back and check to see if you received any notices as reminders to fill out your annual statement?
And I did, and I thought I was sending it. It was a messy situation, sir. I'm really totally honest with you. I'm not the lawbreaker, and I would never postpone, or I would never, not to follow instructions. And then I did go on the website, or whatever, the link was given to me, and I filed even maybe twice. But apparently, I was doing it wrong. And then the question that I misunderstood, it was like, it's requesting me if I have any other income. Like, that was my glitch. And then in my mind, I was thinking if I work somewhere else as well, like if I have another income or resource coming into, or gifts or whatever. And that's what I left it blank because, this is the only workplace that I worked, since 2020.
Right, right.
And as you can see in the past history, after the 2021, everything is squared away because I was asking, the following year, I was asking what I need to do with my paperwork, how to complete it correctly.
Right. And then I would imagine you filed it on time
Yes, sir.
the following
Yes.
year, and you did it not with the Ethics Commission, but with the Chief Clerk's Office in the House of Representatives?
That is correct. All of the other ones, because I said, oh my goodness, I don't really need this mess. What have I created? And I was just stressing out because I did not understood, and I didn't understood what I needed to do.
Okay.
Anything else differently that I've been doing. I thought that was my way was the correct way. No, I did not work anywhere else. Nobody's giving me any gifts. I don't have another income. Yeah. And my apologies for that. So it's all my fault because, I did not question, I did not understood. To me, that was a clear cut, like, yeah, I don't have no other income or resources.
Thank you, Ms. Bartha.
You're welcome.
I don't have any other questions for you. Does any,
I have a question, if I may. If she started work,
I'm really embarrassed, and I'm really sorry about the whole.
if she started work in
confusion and
2020,
everything, because
and this is for the 2021 calendar year form, this would have been the second form she was required to file, not the first, wouldn't it?
I would never do anything to jeopardize my integrity or, do anything other than just be honest and, here to accept whatever I have to do to correct this mistake of mine.
Ms. Bartha, my name is Mike Schwartz. I'm the chairman of the commission. While you were just talking, another commissioner, Commissioner Leipold, had a question for you about if you started work in 2020, was this the second form that you failed to file timely, or was this the first form?
This was the very first form. And being new to the system, new to the state, new to the employment, that's the honest answer.
Thank you.
You're welcome, sir. I don't think I have any other issues ever since then. Every year I file on time, correctly, that the way it's supposed to be. That's why when I received this notification, I was in shock because I said, oh my gosh, after a few years, we're going back to 2021. And then first I thought it was last year's, and I said, I've been doing it correctly since, yeah, so, yeah.
yes. No, that's, thank you very much. Would the
You're welcome, sir.
Would the investigative department have any comments at this point in time?
Yes, there's just a few things that I'd like to clear up.
Okay,
Yes.
The first thing is that she didn't fail to file a form. She filed a form with us deficient. She filed none for her Block 10 income. And I just want to do an overview. We do quite a massive amount of notice given to people when they file deficient forms. So I want to give you an overview of that so you understand the steps the investigative division took in this matter. So
And
she.
I received that, and then I went back to the form, and I completed, but every time I believe I left that block out, blank, because, again, in my mind, I was thinking that I don't have no other extra income coming in, it's only my paycheck through, the state.
okay, thank you.
That's my honest answer.
Thank you, ma'am. I understand that. I just want to get through this. If you could just let
And I
me
did not
explain this.
understand what I was doing wrong. I said I was completing this form. I was repeatedly, every time I got the email notification to go back and then it's incomplete, I did,
Right,
completed the form, but I sent it in blank, that block 10, I believe, which after the 21, in 22, 23, I was completing it correctly. So, yeah.
Ms. Bartha, this is the chair, Mike Schwartz again. We understand what we'd like to do is give the investigative division an opportunity to respond from their perspective. We will then give you another opportunity to respond. So if you can, for just a process purpose, listen to what the investigative division is now telling the commissioners.
Okay.
If you have any questions, concerns, different view, we will turn back to you and give you an opportunity to respond. But if you can let the investigative division take their turn, then we'll come to you, okay?
Okay.
Thank you.
Okay. You're welcome, sir.
Thank you. So what I'm about to describe all happens before we send any warning notice letters or anything goes towards a civil penalty. The first email was sent from our office to Ms. Bartha on March 30th after she filed the deficient form. We sent a second email on May 10th and a third email on June 9th. After those did not result in any, fixing of the issue, our administrative officer called Keisha Wright from the House Chief Counsel's office and asked for her help in getting this situation resolved before we had to get to any kind of civil penalty. Ms. Wenger also sent an email confirming that conversation with Ms. Wright. After this did not work, we entered the civil penalty notice. The first notice was sent on February 1st, 2023. The second notice was sent February 23rd, 2023, certified and signed by Ms. Bartha on February 27th, 2023. Neither of those resulted in the correct fixing of the deficiency, and the warning notice letters contained what the deficiency was. We filed a petition on October 16th, 2023, sent certified and signed by Ms. Bartha on October 8th, 2023. Ms. Lehman, our investigative counsel, spoke with Ms. Bartha that same day, spoke to her about her options in filing an answer, asking for a hearing, entering into a consent agreement. Ms. Lehman approached myself and Ms. Fox with saying we should settle this for $150. We agreed, sent the paperwork out on October 20th. That was not returned to us, and so by November 20th, 2023, we filed the motion for default. On November 30th, 2023, Ms. Lehman had an email exchange with Ms. Bartha, where Ms. Bartha, said what she's saying here. I know I messed up, I didn't do it. I'll file the consent paperwork. That was all taken care of in December, and then we got the letter from legal saying they received the paperwork on December 11th. And we're here today, and that's the entirety of the contact that we've had. I just wanted to give the commission an overview of that.
Much appreciated.
Thank you. Ms. Bartha, do you have anything else to say in response to that?
No, sir.
Okay.
Everything and all, it was correct.
May I just ask, whenever you were notified several times, why didn't you get back early on in the process?
To be honest with you, sir, I did not know. I mean, again, in my mind, I was doing what I was told to do, and then with all those emails, and then, you know, I got scared. I was in shock and scared, you know, when I received the certified letter and I had to sign. I said, my goodness, what have I done? I mean, what am I missing? And then I went over to my colleague, and then she explained to me, she said, oh my goodness, Amy, you should have said something. And I said, I've been filing, you know, or I went on, and then the statements, and then I was plugging in the information. I resend it at least 3 times, and I don't know. So that's where I got, when Ms. Lehman emailed me, and then I got in touch with her and we talked, then I knew that, you know, whatever needs to be done, I will just follow through and then I will do it. It's not like I wanted to break the law or I'm not following the rule purposefully. It was, I don't know, and then since August, I lost 3 friends of mine, and so, yeah,
Okay.
that's all I have to say.
Okay.
My mind wasn't there to comprehend what I thought whatever I needed to do, I did. And I just did not understood why do I receive this emailing, you know, and then the certified letters and all that stuff when I'm doing what I'm supposed to do. But each time apparently what I did, it was wrong because I left that lot number 10 empty, blank. And to me, that's all it was. Like, what am I doing wrong? And then that's when I got the talking with my colleague, and then I said, what am I missing here? So she guided me through, and then you know, whatever, when I have talking to Jennifer, then Ms. Lehman, then I thought I was getting back on the track.
Okay. Do you have a question?
I'm here to correct whatever I need to do.
If I may,
Yes,
Mr.
please.
Chair, and perhaps this is for the investigative division because I'm having a hard time following, but how many times was the form resubmitted and deficient? Or are we talking about one submission of the form? Because from the materials, I'm having a hard time determining how many deficient submissions there were.
We only had one submission of the form that was deficient, and the block 10 wasn't left blank. It was reported that there was no income.
No income, whatever I did, yes.
And that's the only
I
thing
don't
that we
remember
have.
that, sir. I left it blank where I said no income. It just proves that in my mind, I thought I don't have no other income than just my paycheck from the state. That's the honesty, and I cannot answer anything different. And I'm not trying to cover anything. I'm not trying to deter from the truth. That's the God honest truth. 1,000%.
Thank you, Ms. Bartha. Any other questions from the commission? So at this time, I think Commissioner Reddycliffe would like us to enter into quasi-judicial deliberations. So Ms. Bartha, what that means is the commissioners are now going to discuss your case. We're going to ask the investigators and the investigative division and the public to leave the room for a few minutes. We're going to disconnect your phone call. And what we're going to decide is either whether to accept the consent agreement, which is what you had signed, but we have to decide whether to approve or reject the consent agreement. We reject it, then the investigative division will have to be in touch with you as to whether they decide to proceed or they decide not to proceed further. Those are the options. You will get a notice after this meeting of what option the commission decided. Do you understand?
Yes, sir.
Great. Thank you very much. We do appreciate your input today, and thank you.
For working with me and trying to figure this mess up, and then, you know, and again, that's the only truth. I state my, you know, I stand in truth, and as the following statements were correct. So this was my very first one.
Understand. We understand. So thank you very much.
I appreciate your time and then for having me on this meeting, and then thank you for all you do. Whatever is the funding, I will be, I'm taking responsibility.
Understood. Thank you.
Thank you, sir.
Thank you.
Thank you.
If we could ask the public to, just for a few minutes outside, and I don't mind if you leave that camera there, but if I can have your assurance that the camera is off.
Yeah, I'm on, this is my phone, so I'll just take it.
Okay, thank you. Appreciate it. This should be just a few minutes. We are back on the public record after a quasi judicial deliberation. Commissioner Redcliffe, do you have a motion?
I do. It's the Mies Barth is one of the second civil penalty case with the proposed consent agreement. And I would move, Mr. Chairman, that the commission approve the consent agreement submitted by the party imposing a $150 civil penalty for failure to timely file a statement of financial interest for the year 2020-21. And I further move that to the extent that the respondent has not already done so, she be ordered to pay the recommended civil penalty amount agreed to by the parties for the consent agreements within 30 days of the issuance of the commission's order, and also file her financial interest for 2021 within 30 days of issuance of the commission orders.
Is there a second?
Second.
Motion has been seconded. Any discussion? Seeing no discussion, all in favor, say aye.
Aye.
Any opposed? The motion carries. All right, I think we have a default civil penalty order. Commissioner Redcliffe.
Yes, respondent Renee Boris failed to file a statement of financial interest for calendar year 2021. The respondent did not act or respond to the civil penalty proceedings. So it is my opinion that the commission should levy a maximum civil penalty of $250 for the delinquent statement of financial interest. And that the respondent should also file their delinquent statement of financial interest. There is nothing of record that would constitute a defense or excuse for their noncompliance. So, Mr. Chairman, I move that this commission levy a maximum civil penalty against respondent Renee Boris in the amount of $250 for failing to file a statement of financial interest for calendar years 2021. And further, she should be ordered to file a complete and accurate statement of financial interest for calendar year 2021 within 30 days of the issuance of the commission's order.
That's a motion. Is there a second?
Second.
Motion's been seconded. Any discussion? All in favor, say aye. Aye. Any opposed? Motion carries. Let's turn to lobbying. Commissioner Parcells.
Okay. There's one default administrative penalty case for our consideration. Respondent Urbane Development Group Limited is a registered principal that failed to timely file either a quarterly expense or statement of failure to meet the reporting threshold for the second quarter of 2023. Warning notice was issued to the respondent by certified mail. There was also follow-up emails that were sent, and there was no response whatsoever. Based on the record before us, it's my view the respondent's transgression of the lobbying disclosure law was negligent. In accordance with the Commonwealth Court's decision in Penn Film Group, the record was examined for any mitigating factors such as those outlined in section 63.63 of the Commission's regulations. Other than this apparently being the respondent's first delinquent filing, there is no evidence of any other mitigation present in this case. Mr. Chairman, based on the totality of the circumstances in this case, I move that this commission levy the respondent Urbane Development Group Limited, one maximum administrative penalty in the amount of $30,300 for its failure to timely file with the Pennsylvania Department of State either a quarterly expense report or a statement of failure to meet the reporting threshold for the second quarter of 2023. And finally, I move that the respondent be ordered to pay the aforesaid administrative penalty by no later than the 30th day after the mailing date of the Commission's order. My motion.
We have a second to that motion.
Second it.
For discussion, I do have a question I'd like to ask. Does anyone else have any questions first?
Yeah, I just would ask Jeff or Mary, I know I have some familiarity with these types of things. What type of response or have the correspondence or communications with the Urbane Development of why they didn't file? What was the?
Sure. So I can tell the commission that we have received no response at all. And to give a little bit of background on the type of notice that we provide, similar to how I did in the civil penalty conversation, prior to the deadline of, for each quarter, the Department of State does a robocall and sends an email to all registered filers. Once the deadline has passed, the Department of State sends us a list of everyone who did not file. We then generate warning notice letters, and we send a warning notice letter on this case in August 25th, and we send it certified mail. It's not required to be sent certified mail, but we have changed our procedures recently to do that in order to just make sure we're getting the service. It was delivered August 28th, 2023. And then Ms. Lehman, our investigative counsel, also something that I developed once, if you remember back in 2018, the lobbying law was updated to include an authorized representative, name and email address. And so what we do now is we send an email to the authorized representative following us sending a warning notice letter because we just want to get compliance. So Ms. Lehman sent an email on September 25th to the email listed on the principal's registration statement. She got an automatic reply back with 2 other email addresses, and she sent the same email to those addresses. We didn't hear anything back. We filed the notice of noncompliance October 19th, 2023, sent certified once again, delivered October 23rd. We haven't heard anything from this respondent at all.
Thank you. And just for the record, I want to make clear, and Ms. Guilfoyle, we tried to reach out to this respondent to see whether or not they were going to participate today, or no?
No, we did not.
Okay, this was a default, so we have
Right.
not heard from them. Okay, I just wanted to see. I had similar questions to Commissioner Caruso, but when we heard about the last procedure point, there was also a call made. Was there ever any attempt to call any of the contact folks here?
There was not in this case. I can tell you our procedure for this is based off the regulations in 51 PA Code 63.4. It's the non-investigative process for later deficient filings. We also we can elect to proceed via an investigative process pursuant to the regulations, but that would involve opening a preliminary investigation. It takes a lot more time and resources for these that the way that the law basically says these is that it's either filed or it's not. If they file an answer, it's almost like an appeal, the way that the law treats it. And that just requires us to provide notice. Now, notice is defined in the regs as official papers are deemed served on the date of mailing, and it doesn't really say, and we use certified mail. And that's all a way of saying we try to do a little bit more than is necessary, but we did not call, there was the robocall placed by the Department of State. And the only time we really ever call is if, and this happens very rarely, is if we send the warning notice and it's returned either undeliverable or not picked up, whatever the case may be. In that case, we're worried that there could be another violation, such as failure to update the registration statement. So what we do in that case is we try to call anybody else listed on the registration statement, like a lobbyist or something. They typically don't like when we do that, the lobbyists don't. But we try to call them and ask, hey, do you know if this is still an entity in existence? Because that could later come into play during collectability issues, things like that.
Excuse me, Jeff, did you call the lobbyist in this case?
No, we did not, because we had all the certified letters were signed and received back.
So that was a follow-up question. So we actually got a return from a representative of the entity that they had received the letter?
Yes.
And I asked these questions in part for the new commissioners under our Penn Film Group case that was sent back to us from the Commonwealth Court before we impose a maximum statutory penalty. And as you can see, the lobbying law has statutory penalties that are much in excess of our ethics filing. We need to consider all of the potential mitigating factors and aggravating factors. And I think these notice, or the information that you've provided to us, Mr. Frankenberger, is important for us to consider. We have a motion and a second, but whether or not the maximum penalty or some other penalty is appropriate.
Thank you, Your Honor. And I think maybe it's something the investigative division can do, maybe in our notice of noncompliance, to maybe list some of this stuff out so that you have it ahead of time instead of having to ask questions like this at the hearing.
I think it's important to think about, for purposes of lobbying defaults or even consent decrees where we're looking to make sure we're fulfilling our obligations under the Penn Film Group case, and hearing about the multiple efforts, the follow-up emails, the return certified letters, I think helps us understand whether or not a maximum penalty is appropriate. So I think that would be a good approach. Any other questions?
Yeah, I have one. I don't know if it's appropriate or not. I noticed this is for the second quarter of 2023. Is there anything about the third quarter?
So we have begun noncompliance procedures on the third quarter, and it's public record. You can go on the lobbying website. They have not filed their third quarter as of yet either.
Any other questions? We have a motion, we have a second. Let's take a vote. All in favor? Aye. Any opposed? No, motion carries. We have a number of administrative matters. First, some education training updates. Ms. Fox?
Yes, thank you. I just wanted to provide the commission with an update on some of the things that we're doing. Many of these things have been done long-term at the commission for many, many years, and we've continued with them. I laid out in my memo some of the things we've done. We've done quite a few in-person and virtual trainings. We've trained approximately 1,400 people through live trainings, either those virtual ones or actually in person. A couple of weeks ago, Jeff and I trained and videotaped a training that's going to be shown to all senators and all Senate staff. So that should really have a pretty extensive reach, hoping that it reduces Ethics Act issues and increases compliance with statements of financial interest filing. We created 6 short little explainer video clips about some of the major topics: conflict of interest, what's a public official, public employee, shared those through social media, trying to just get the word out about, what a violation looks like, what we do, and who's subject to our law. We also did one on lobbying disclosure. So those are on our website. I'd love for you to take a look at them. We actually retained another state agency to do those for us, and I think they were maybe $200 for the entire cost. We've had more than 1,000 total views of those too, so hopefully they're having a good reach. We refreshed older training videos that had been used in the past. We had live actors in the past, but we refreshed them with some animated little clips about what Ethics Act violations look like in real life. And we don't just provide those to the public. We use them as part of a training, but they have been extremely well received. People ask us all the time, can we get a copy? But they need context, so we don't like to provide them in a vacuum. We have created a compilation of all appellate cases involving the Ethics Act and lobbying disclosure law, and we're putting the finishing touches on it, hoping to publish that on our website, and we'll keep up on updating that. We've worked with legal, investigative division, administrative division, and legal. We've all worked together to pull that together. We think it'll be helpful for public, for us even, for lawyers who practice before the commission. So I'm working on that. We published the legislative history for all three versions of the Ethics Law, Ethics Act. Those are on our website. And we created a web-based training that we're going to start using as part of a consent agreement. So if somebody violates the Ethics Act, we can have them agree to take a training, and we can keep track of that through this. It's a bit dull, but it does the trick. And then we've created an internal investigator manual with guides, forms, tools, things like that. It's an electronically based document for all of our investigators and our attorneys in-house here to use as a resource. It's to share information, and it's pretty comprehensive, and I think it's going to be very valuable. And then lastly, we're looking to purchase a license for it's a product called Articulate 360. It's a license through the Office of Administration, and it's a web-based training module that we can use to create short or long interactive web-based trainings on the Ethics Act. So it's actually extremely affordable. It's $1,100 for the year. So we are working on pulling together that license agreement so we can purchase that. And then we have support through Office of Administration. I don't think it's the easiest program to use, but they have trainings, in-house trainings that we can send our folks to help put together some attractive and interesting trainings. So we just want to really try and get our reach and the information out there to as many public officials, public employees, and the public as we can. So if you guys ever have ideas about additional ways to do that, please let us know.
Excellent.
Good.
Why don't I have you just go through the rest
Sure.
of the administrative
Sure.
matters?
I wanted to give you an update. Starting November 6, 2023, we started accepting credit card payments, which we had never done before. We did it through a project that was done through the comptroller operations through a product they created called SnapPay. It's relatively new, so this was a good opportunity for us to start using it. There's no cost to the agency. People who are paying can either use ACH, which is the automatic transfer, which is free, or they can use a credit card with a 2% fee that's passed on to them. So we've seen, last I checked, when I was putting the materials together, we had, I think, 3 payments come through, totaling $13,500. My hope is that making it easy to pay will make people more likely to pay, and it'll be easier to collect. So we'll kind of we'll give you updates on that as it moves along, but it's been very useful. Let's see. I need to update you on the medical marijuana list. So one of our duties is that we are to biennially publish a list of people who meet the definitions of public official and executive level public employee as defined in the medical marijuana law, which bounces to the gaming law. And so the 2 years was up, and so we worked through the end of 2023 to reach out to all state agencies that would have employees or officials that might be subject to this law. So we followed a similar process that we had done in the past. We sent letters out to leadership within all those agencies. The medical marijuana law also requires Office of Administration to help us with the state lists. So we did receive quite a bit of help from their counsel in deciding who within those agencies would be subject to the definitions. So we completed the list for the state level with some back and forth. We don't really do independent research into all of these positions. We don't, for a number of reasons. One, we don't really have the manpower to do it. And the second is that we do rely on the public officials and public employees within those agencies to assist in doing that analysis. And so we pretty much take the state lists at their word. What's new for this year is there were distributions under the medical marijuana law for some local agencies. And so we had to start kind of a new process for that, where we reached out to these local agencies who had received the money and asked them to provide us with lists of folks who would be subject to the law. Usually that meant working with their solicitor. We heard back from almost all of them. There were 3 that we did not get lists from, although just earlier this week, we did hear from Jeanette Burrow, and they did provide us with a list as well. So we're working through that. I have some confusion about the definition of executive level public employee and how it applies to the local level, at the local level. So we're meeting with the Department of Health's medical marijuana people next week to get some more information about who has the authority to maybe make arrests or make decisions under the medical marijuana law at the local level, because there may be a wider reach than what we're thinking of right now. We're gonna update the list then if we feel that we need to do some additions to it. The list is slated to be published on January 20th through the Pennsylvania Bulletin, and we will be posting it on our website too.
Mary, can you give us an example of the offices currently being named or labeled in the municipalities?
Sure.
I mean, is it the township manager?
Sure.
Is it, you know, and is there a consistency between the 8 now, because as I recall, there were 7, and if you're adding Jeanette Burrow, that would be
Yeah.
8.
Yes.
So is there consistency between them?
There is a lot of consistency. So most of them are listing, like for example, the boroughs, mayor, council members, borough managers, chief of police, deputy chief of police, police sergeants, detectives, corporals, police officers. The definition specifically includes individuals with law enforcement authority. So there is that consistency among the different municipalities.
But in other words, you know, let's say that one municipality sends in everybody that you just mentioned, and then the next municipality sends in the mayor and the chief of police. Are we gonna go back and say, well, you gotta name everybody else, or are we just going to say, hey, that's fine with us, you've sent us a list, because the law says send us a list, and we're not going to be going out, like you said, you know, we don't have the manpower to monitor it. So are we gonna be okay with, you know, a 2-person list as compared to a 20-person list?
Yeah, well, we haven't seen it yet, but
Okay.
if that came in, we might push back and reach out to the solicitor and say, hey, are you sure this is comprehensive? We don't know what all the positions are within all these municipalities, so and there's not always consistency from one to the next.
Right.
But if something's jumping out at us, we would reach back out.
Okay.
That's a good question, because many of those positions, they're already public officials under the
They are.
Ethics Act. Police is an interesting issue
It is.
because this is only for those township, boroughs, cities that get money under the medical marijuana law.
That's how we've been interpreting it. I'm meeting with Department of Health to make sure that we're not looking at it too narrowly, because I think there is an argument that it could be a bit broader for the executive level public employees.
Because traditionally, state troopers, municipal police are not subject to the financial disclosure, am I correct?
Correct, you're correct, yeah. So yeah, we will, we'll continue to look into this. We want to make sure it's as accurate as we can make it. For the entities or the governmental entities that didn't respond, I would like, and I'm planning to maybe not start with the civil penalty process. We do have the ability to pursue civil penalties against public officials, public employees within the municipalities who didn't respond. I think because this is new, I'd like to take a bit of a more gentle approach, reach out, call, see if we can pin someone down. We have been ignored for multiple efforts at contact, but I do think I want to start this first go around with more of an educational perspective before we start coming out and threatening civil penalties.
And one final question that I have, what is the purpose of the list?
Well, that's a great question.
Something the legislature threw in.
Yeah, so it does, it includes restrictions. It restricts some of these individuals from having activities, and I need to pull it and
Okay.
double check
All
and,
right.
yeah, provide that, but.
Send that to
Yeah.
us,
I'd be
because
happy
I'm
to.
curious as to, I mean, this is just one of those, I don't want to say knucklehead ideas that doesn't mean anything, but, you know.
We're retired, Dave.
Oh, I can say whatever I want to say.
You know, I think I wanna make a very good faith effort
I know,
to get this as comprehensive as possible. Will it ever be 100% accurate? I don't know, but we'll do our best.
Okay.
Okay.
Other administrative updates?
Yeah, I wanted to let you know that, of course, the audiovisual project here is complete. We use it all the time. We use it at least once, at least every other week, for conferences and investigative meetings with our Pittsburgh office. We've used it for interviews for folks who were far away or maybe couldn't come in. We had some illness amongst our own staff and they were able to participate in some of the interviews through the system. So we use it a lot. It's been working really well. We've had a few bugs. Luckily, hopefully we don't have any bugs with today, but it looks like it's all running very well. So we wanted to do a similar project at our Pittsburgh office so we could integrate. I want to integrate everything in this conference room, the Pittsburgh conference room, and all of the iPads that you guys have through Teams. So it's very easy for us all to communicate even at a distance. And so we have selected the same vendor. We did a competitive process through a state contract, selected the same vendor for our Pittsburgh office. We should be beginning that project probably sometime in the spring. And we're gonna scale it back some. We don't need to have live streaming, out there, but we'll be able to hopefully very easily communicate and it'll help us work together well, so. Just really briefly, we've been hearing about different benefits offered to state employees, and I wanted to make sure our staff had the same opportunities. Penn West Online University, which is, I think, Clarion, California, and Edinburgh, offer a discount to state employees of 20% off tuition. So we, after discussing it with the chair and vice chair, we entered into a memorandum of understanding to offer that same benefit to our staff. No one's taken advantage of it yet, but it's there. And there's a similar benefit that we just heard about for York College. It's York College that we're going to look into as well. But it's an online program, and it's just furthering folks' education at a discount. So we want to really do the best we can also to keep up with what other agencies are offering to their staff.
I think the last item on the agenda for the public meeting is an update on our regulatory update process.
Yes, for our newest commissioners, just so you're aware, we are attempting to update our regulations that are sadly outdated and have not been updated in quite some time, several decades. So what we decided to do was split it into two separate processes. We did a technical revisions where we went through and changed. We had some outdated addresses. We had some outdated statutory references. So we went through and did those first under what we call the technical revision package. And then we have a second process that we're working on that we're going to do more substantive revisions. The technical revision package ran into a bit of a hiccup, and the commission voted to withdraw that package on November 17th, 2023 at the suggestion of the Chief Deputy Attorney General, Amy Elliott, because when she reviewed the package, she had a couple of concerns that I mentioned in the memo that's in your agenda items concerning. One was the definition of the word advice. And the second, probably more major concern was, even though we were only attempting to correct a statutory reference, the statutory reference was actually to a section of the law that had been declared unconstitutional by the court in 2010. So we have addressed those issues, and the revised final amended rulemaking package is ready to go and will be submitted to IRC, the Office of Attorney General, and the standing committees of the General Assembly. When I initially did this memo, my intention was to do it immediately after the holidays. I contacted a friend of mine at the House, and she informed me that doing it right after the holidays was probably not going to get good service over there. I have to serve everybody on the same day and get proof that I served them on the same day. So even though I can serve them, getting them to actually respond back and say, yes, I got this, if I don't get that, then I have to start again the next day and keep doing it. So she suggested that I wait a couple of weeks, so I'm going to the beginning of next week. I'm going to try and get good service on everyone and get it submitted. So that way, hopefully it'll be considered by IRC at its meeting in February. For the substantive revisions, we are working on a subcommittee basis with the chairman and Commissioner Caruso, where we are, and we've also decided to enlist, with Mary's permission, the investigative division attorneys. And we are going to go through each chapter of the regulations and go through, we were struggling and I was struggling to find a way to do this. Given my relative inexperience working with these regulations, I didn't know where the hiccups are in there or things that people didn't like and that needed to be, changed or updated. And so by bringing in people like Jeff and Martin Harder, of course, who has been here a very long time, I think that we will be much better equipped to address the concerns that have been in place for a while that I'm simply unaware of because I haven't been here that long. So we decided that we're going to continue working on the committee basis for now until we get something more substantive in writing. And that after that time, we will invite not only additional commissioners to participate, but also any stakeholders such as the PSAT, groups like that Mary deals with a lot in the training as well. And this was a suggestion from the chair, as well as possibly some of the respondents' council that we see here frequently or more often than not, and see what they would like to see if changed, or if there's anything that they've had issues with that we could possibly change and maybe get it through or past IRC. We have a meeting currently scheduled for January 25th, and we are going to go through the first two chapters of the regulations, hopefully to completion during that meeting.
Any questions about that regulatory process? And I know because we're at a public meeting, we welcome public input at any point in time. If anyone has thoughts, suggestions, concerns about the regulations. So, welcome that any public comment about our regulation process gets directed to our chief counsel and would be incorporated in the working group's thoughts about the project. And obviously, all of us will be presented in an open meeting for discussion about any proposed amendments or changes. Anything else for the public meeting? I know we don't have a formal public comment, but is there anyone that has anything that they'd like to raise to the attention of the commission? Hearing none, I'll take a motion to adjourn.
So moved.
Second?
Second?
All in favor?
Aye.
Aye. We are adjourned.